Yeah, Darnell and I have, we had an episode on church and state, and
Mhm.
I was wondering if you could speak to a little bit about maybe um, the idea of separation of church and state. And
Mhm.
we would definitely say it's, perverted, where they say, oh,
Mhm.
that means the church can't speak to the state, where in reality
Mhm.
it should have been the state's not
Mhm.
speaking to the church.
Right.
But I'm wondering if you can also, how do we define our constitution such
Mm.
that things like this would not be permitted because it's clearly,
Mhm.
as you put it, a religious law
Mhm.
or,
Mhm.
or a religious
Yeah, I mean,
document.
yeah, no, exactly. Yeah, a couple of thoughts, and that's a great question. I think, first of all, I mean, every law is a moral document, right? The tax code, I believe, is a moral document because it's saying certain things are going to be taxed at higher rates than other things. For example, taxing, alcohol and cigarettes at a higher rate than others is a form of there's a morality behind that, or taxing higher income earners at a higher rate than lower income earners there's a moral or there's a moral calculation going on there to make that kind of a decision. So in every aspect, law and legislation, there's morality underneath it. But to the point of separation of church and state, I would say anyway, is that those are two different institutions with two different sets of obligations and responsibilities. And the church shouldn't try to do the civil government's job, and the civil government shouldn't try to do the church's job. Those are distinct institutions with distinct responsibilities. Now, that's very different from saying that somebody who is a member of a church can't bring their faith to bear on a public debate about what is good, right, true, beautiful, as far as public policy goes. Of course, public policy needs to be informed by a religious worldview. You can't have a truly neutral worldview. And so what I would say is, as it relates to this particular law and a constitutional challenge to it, and I think this Bill C4 is constitutionally suspect at best. I think there's a decent chance that the courts may either strike it down or read it down. It's more likely that they'll read it down. What that means is they won't strike the rule from the criminal code, but what they'll do is they'll say, look, when you're applying this law, you have to apply it very narrowly to coercive and torturous practices um, that are done in a sort of therapeutic medical kind of situation, something along those lines. So I think that's where the judges may bring it that way. But yeah, to that, I think that's where our Constitution should be kicking in. The Constitution should be taught. What our judges are actually tasked to do as interpreters and appliers of the Constitution is they should be saying, look, the Charter speaks about freedom of religion, and the Charter speaks about freedom of expression, and the right to life, liberty, and security of the person, and these rights protected in Section 2 and Section 7 of the Charter, they should allow for the free exchange of ideas around these value judgments, free exchange of ideas around what are good sexual ethics and what are bad sexual ethics, good ideas and the exchange of ideas around religious claims about what it means to be human, what it means to be male, and what it means to be female. And so, that's what the charter exists to do, is to protect that kind of debate and deliberation. So as long as, quote unquote, so-called conversion therapy, so broadly understood, as long as that's being done in a non-coercive way, then we shouldn't be criminalizing it. I think that, yeah, and my hope would be that a court would recognize that and say, look, this bill goes way, way, way too far.
Mhm.
Please subscribe and hit the bell to stay up to date. If you liked or disliked the snippet, give it a like and share your 2 cents with us in the comment section. And remember, 6 cents makes change.